Robert Potts is appealing 2 assault convictions and 1 unlawful imprisonment conviction involving his wife and another for the unlawful imprisonment of his stepdaughter. He contends the trial court erred by excluding testimony from neighbors regarding his wife's reputation for dishonesty. Additionally, he challenges the conviction for unlawfully imprisoning his stepdaughter on the grounds of insufficient evidence. Potts and his wife, Megan Francis, were married, and Jane was Francis's child from a previous relationship. Potts helped raise Jane from a young age, treating her as if she were his own, and, with Francis' permission, Potts occasionally disciplined Jane. On one occasion, Megan and Jane began arguing loudly about household chores. The argument woke Potts, who had been resting in the basement. In response, Potts rushed upstairs, took Megan by the wrist, and forcibly dragged her down to the basement. Once there, he yelled at her for waking him, pushed her onto the bed, and choked her. As a result of the choking, Megan experienced dizziness and had difficulty speaking. Potts then ordered her to remain in the basement, and Megan, feeling frightened, complied. He proceeded to bend her over his knee and strike her with a belt. Megan reported that the pain from the belt lasted for 3 days. After this incident, Potts called Jane down to the basement. When Jane arrived, she saw her mother crying in a corner. Jane had witnessed Potts physically abuse her mother on previous occasions. Potts then threatened to strike Jane with the belt. Although Jane was afraid and wanted to leave, Potts ordered her to stay in the basement. He was convicted, and now he appeals, arguing multiple errors. Let's take a look.
Mr. Potts has raised 2 assignments of error in this appeal. Unless the court has specific questions that they'd like me to address on the first issue, it is my intention in this argument to focus on the second, which is dealing with the sufficiency of the evidence in support of the conviction for unlawful imprisonment.
I have questions with regard to the first
Your Honor.
issue, which I will label as reputational evidence.
Yes.
How many people must form a community in order to permit reputation evidence?
Your Honor, we don't have a bright line rule that we can ascertain from the case law. What we do know is that the community needs to be sufficiently large that it's general, that it's a sampling of a general population and not just a cherry picking of select people with select opinions.
How many were in the community that Mr. Potts sought to use in his trial?
Your Honor, the exact number of the people in that community is not preserved in the record. What the record reflects from the offer of proof was that the neighborhood consists of a number of houses that are closely situated together and in which the neighbors are generally acquainted with each other. They hang out on their front lawns. They do things with each other. We did see from Mr. Potts's witness list that he had identified, I believe, 5 neighbors as potential witnesses. Only 2 of those were actually called at the trial in light of the trial court's ruling.
How many people did he intend to call to testify as to the reputation of the victim?
Your Honor, the record indicates that it appears he had a total of 5 witnesses. 2 of them were neighbors known as the Nears. Both of them did testify. Then there was an additional witness, Jeff Berman, who was also an acquaintance, somebody from this area who knew them by reputation, who also testified. There were 2 other individuals on the witness list that did not testify based on the representations that were made by Mr. Potts's attorney. It appears that his intended witnesses were neighbors directly next door, directly across the street, and somewhat down the block. So I think from that record, we can infer, because the Nears were the next door neighbors, that the neighbor across the street and the neighbor down the block were not allowed to testify.
When advocating for reputational testimony, did defense counsel solely rely on the Nair declaration when informing the court what the potential testimony would be?
No, Your Honor. In fact, counsel repeatedly stated that he understood the limitation was general reputation testimony, that it related to the witness's reputation for veracity and honesty in the community, and that is what the testimony would be limited to. He did not intend to raise specific instances of alleged misconduct or otherwise, raise improper type of impeachment evidence. According to his proffer, this testimony would have been squarely within the parameters of Rule 608.
Did counsel indicate the source of the potential witnesses' knowledge of the reputation of the victim?
Your Honor, only through the context that we've already discussed, given the nature of the neighborhood, the fact that the houses are closely situated, and so there is a lot of communication between people just out on the front lawn, and that this is the type of neighborhood where there's frequent contact and communication between the neighbors, so that there is kind of a general acquaintance of the folks in that area.
Did the Nair declaration go to what the Nair's individual opinions were as to the truthfulness of the victim, as opposed to the victim's reputation for truthfulness in the neighborhood?
Well, Your Honor, I think there is some overlap, and part of the problem there is because the Neirs were also percipient witnesses to some of the circumstances that led up to the events that caused this criminal charge. So yes, I think it's fair to say that the Neirs did have a personal opinion, but that they did not only have a personal opinion, that they were also familiar with her reputation in the community and would have testified to that.
You may, unless, go ahead, Judge Staub.
Thank you. So just so that I'm clear, it looks like Judge Pleas closed down defense counsel because she didn't feel that this was a community and never really got the question as to the distinction between reputation and opinion testimony, correct?
Yes, I think that that's fair. I think that there were two aspects of the trial court's ruling that were dispositive in that reasoning, both of which I argue are a misinterpretation of the legal standard. The first is that the area where she resided did not constitute the community, or that there was an insufficient showing that it constituted the community. The second reason was that the individual witnesses themselves, according to Judge Pleas, would need to be impartial and unbiased. That is not a requirement that's reflected in any of the case law or in the rule. Certainly the reputation needs to be generally derived. It can't just be one person's opinion, but that doesn't mean that a person who also has a personal opinion can't testify and then be subject to the same types of challenges about their veracity, their bias, and things like that as any other witness offering any other type of evidence.
Well, isn't there a case law that says that the witness offering reputation evidence needs to be neutral?
No, Your Honor, there is not, to my knowledge, a requirement that the witness themselves be neutral. The requirement is that the community be neutral. You can't go out and just cherry pick a select group of detractors and say this person has a bad reputation within that select group. But to require that the witness themselves be impartial would essentially kind of undercut the possibility of presenting this type of reputation testimony at all, or at least a substantial amount of the time, because a person who is a member of this community, who is going to be in a position to have these types of impressions and opinions, is likely to have an opinion of their own. So to require that person to be completely withdrawn and abstract in their evaluation would take them out of the context that they really need to be in to have that knowledge in the first place.
Ms. Burkhart, I don't know if Judge Pleas just didn't allow it, but I'm not seeing where in the record there was a proffer that these specific witnesses knew of the reputation in a particular community. You're familiar with how the how you present this kind of testimony. You ask someone about the community, and if you're aware of the reputation in the community, where could you cite the CPs where they're saying that they know her reputation as opposed to just saying she's a liar? But where do they say, I belong to this community, and within this community, she is known for having this reputation?
Yes, Your Honor. So this was addressed on the record. It's in the verbatim report of proceedings, volume 1, at approximately pages 477 to 489 is the colloquy that was engaged in on this. If the court would like to give me a moment, I could probably find you some more specific examples.
Was it just the attorney saying that they can testify, or did the witnesses ever proffer that they were, because it probably would have been helpful for Judge Please for the witness to say, we're a member of this community housing association or whatever, and in this community I am familiar with this person's reputation for truthfulness, or what is the character trait that we're talking about, and that reputation is she has a poor reputation. Is that there besides the attorney's proffer?
Your Honor, what there was is a general proffer that was descriptive, as you've described, where counsel is basically describing what he anticipated the testimony would elicit. There was a suggestion by defense counsel that he was willing to bring in witnesses to establish the community, the nature of the testimony, and so forth, but the judge did not allow that. So there are basically just, from my perspective, of course, the proffer could always be better from appellate counsel's standpoint. It is not as, I suppose, crystal clear and black and white as we might like, but it does repeatedly indicate from counsel that he is aware that what is being elicited and sought is reputation evidence, and that is what these witnesses would be able to offer.
Okay, thank you.
Ms. Burkhart, you may want to move to the, I can't remember if you described it the first or the second issue, but it would be the sufficiency of evidence issue.
Yes. Thank you, Your Honor. And so on the sufficiency of the evidence issue, the argument essentially is that based on the way that the crime is defined, specifically the definition of the term restraint, there is an incorporation of the requirements that the restraint be either both without legal authority and without the consent of the person restrained, or in the case of a minor child, the acquiescence of the parent or guardian or person who has control of that child. So there's two ways that applies to a lawful parental discipline scenario. First off, the without lawful authority requirement itself would not be satisfied in a situation where a parent is exercising their lawful authority to discipline a child. The second is, of course, the without consent, the by acquiescence of the parent. And so I've argued in this particular situation where Mr. Potts was the stepfather to this child for over a decade, where she lived in his home. There's indications in the record he had previously disciplined her with her mother's apparent consent and in acquiescence. That under these,
you're into your rebuttal time. You may continue if you wish, but it will be deducted from rebuttal.
I understand. Thank you, Your Honor. So just briefly, the main point that I want to address is the state's argument that they didn't rely on the without consent portion of the statute in order to convict Mr. Potts. My counter to that is that it doesn't matter, because to prove without lawful authority, the state still has to overcome the bar that the parental discipline statute would impose. And second, I would just argue that the state's interpretation that those provisions can be severed is not reasonable. An example that I would give is that if, for example, you're in a grocery store with your child and your child begins to throw a tantrum, won't be sued. You pick up the child and remove the child from the store. You have not not committed a crime by doing that. You have, however, physically restrained the child and used physical control to manage the child's movements. So you can't take the age of the child out of the situation when evaluating what is lawful and appropriate under those circumstances. And so with that, Your Honor, I would request to reserve my remaining time. Thank you.
Ms. Lundgren?
Thank you, Your Honor. I will, may it please the court, I will just begin with the community aspect and noting a couple of things based on what counsel said. The first is just a clarification that I don't believe that the record shows that Jeff Berman was ever listed as one of the witnesses who would testify to reputation evidence. He wasn't one of the neighbors and he wasn't included in that group. And as counsel said, reputation evidence cannot come from a select group of detractors, and that's exactly what you have in this situation. There are 6 people in the Neer household. All of them signed a declaration showing that they have personal knowledge of Miss Francis and have a very negative opinion of her and a very positive opinion of Mr. Potts, have been friends with Mr. Potts for years. So without knowing—
Ms. Lundgren?
Yes, Your Honor.
Did the trial court prevent defense counsel from providing the extent of the proffer of evidence that counsel wanted to provide?
Your Honor, no. Mr. Partovi suggested on the fly that he could parade the whole neighborhood in for an offer of proof. But as the court rightly noted, he didn't have anybody even in mind at that point who would be a neutral witness. So even the Nairs wouldn't be available. So the issue is really that defense counsel didn't establish a competent offer of proof to establish that there even were witnesses who would testify. They were in the middle.
Did the trial court wrongly believe that the witness needed to be neutral as opposed to the community being neutral?
Your Honor, I think in this situation, the trial court was not incorrect in concluding that those witnesses needed to demonstrate that they had some neutrality with respect to offering an opinion as to Miss Francis's reputation, because as far as the trial court knew, there were 6 individuals offered and each of them were highly biased. We don't know the extent of the other individuals in those other 2 or 3 households to know.
I don't know of any rule that prevents someone who's biased to provide reputation testimony. The bias goes to the weight of the testimony as opposed to its admissibility. Is that correct?
Yes, Your Honor. And I'm not suggesting that there isn't a circumstance in which the community itself, somebody could testify and be biased and testify to a neutral community's perceptions. My argument is that in this case, the only 6 people that we know who form the part of the community and who can offer evidence are highly biased. And so in that sense, the community is biased, and those biased members can't really testify to a neutral community or a reputation in a neutral community, if I've expressed that clearly enough.
Let me ask you a question. If you have a community of neighbors and you have one bad apple, somebody who, is known to lie and do all sorts of things, just because they have an opinion of this person that's negative, I don't understand how would you get a neutral community that would have an opinion that a person's reputation is poor? It seems to me that in most cases, if somebody knows that a person's reputation is poor, they're also going to have a personal opinion.
Yes, Your Honor. And I think that goes back to the requirement that the community be generalized and neutral. And so when you're looking, it can't be a hand-selected group of people. And that's, I think, some of what the trial court was talking about when it was trying to assess what does make a community. It can't be a community just because they're hand selected. It must be a community that is general. So if you think about a workplace, somebody in a workplace could testify that one of their coworkers has a poor reputation in the office for veracity. They may have, yes, Your Honor?
Even if there's only 6 of them?
Your Honor, I don't know, like Ms. Burkhart said, that there is a specific number. The standard here is abuse of discretion for the trial court to find whether it constitutes a community or not. I would suggest that 6 is a fairly small number to be deciding that it's a community, but perhaps in a different scenario, under different facts, there may be sufficient facts to find that 6 would be enough. Here, there's not enough because that is not a generalized and neutral community. It is a group of Mr. Potts's friends.
Go ahead.
Well, I'm just wondering if the problem is you're inferring a community and reputation from 6 people who say we have a poor personal opinion. Would this be a different case if 6 people came in and said, well, we have a personal opinion, but we also have knowledge of a broader general community, the west side of town, and in the west side of town, she has a poor reputation for veracity. It seems to me that's the problem. You're inferring a community from 6 biased individuals when you don't even know how to define that community, whereas you could have the same six people all equally biased, but if they claim to know a broader community that included not just them, it would be different. Do you agree with that?
Yes, Your Honor, you've said it much more eloquently than I did. I agree that yes, you can have somebody who has personal experiences. That's true. You just need to have, when you define the community, you can't define it by simply individuals that you've picked as friends who have bad experiences, as opposed to this more generalized community that is defined by something other than friendship to the person that they're seeking to
defined by other than the 6 people you found that don't like them.
Right.
You can't say within the 6 people who don't like this person, they have a poor reputation for truthfulness. You have to say within a community.
Right, exactly. And I would even say that within, perhaps, and the trial court said this, you have, if Mr. Partovi had come in and said, it's this entire block, it's multiple blocks of this neighborhood, we've talked to all of these people, we know that generally in this whole neighborhood, she has a reputation for untruthfulness. Perhaps they could have testified to that, but that wasn't the offer of proof, and that's not established in the record. And so there simply wasn't sufficient evidence for the trial court to find that this was a generalized and neutral community. And so it was not an abuse of discretion for the trial court to deny that testimony.
So, Ms. Lundgren, let me ask you, even let's say that it was error, and I'm just going to go there. The testimony that would be allowed under this evidence rule is really limited, right? Do you
Yes,
have a reputation in the community for veracity? Yes, I do, and it is poor. Correct?
correct.
So what is the standard, given that it's an abuse of discretion, to reverse on this particular error would require what?
Could you repeat the last part of your question, Your Honor?
Let's say we found error. Given the standard of the review, error doesn't necessarily require a reversal. What does the defendant have to show in addition to error?
No, the defendant would need to show that the verdict would not have been the same without the error. Or I apologize, the state needs to show that there is no likelihood that the verdict would have been
Does the state have the burden of proving harmlessness beyond a reasonable doubt, or the defendant have the burden of proving that the error undermined the verdict?
Your Honor, I suppose it depends on whether the court finds that this is a right to present a right, that the trial court violated the defendant's right to present a defense. If that's the case, then it's the constitutional harmless error standard.
What is that? What is that line? Because one could make that argument anytime a judge makes an erroneous evidentiary ruling.
Right. It is that, they have the right to present a defense, but that right is not absolute. And the trial court is still allowed to not admit inadmissible evidence. And so the state's argument here would be that the trial court had a basis to exclude this evidence and so did not violate.
The defense was she's a liar. They weren't able to bring in reputation evidence to show that she's a liar, but they
Right.
brought in other things. And wasn't there a letter that was brought into evidence where
Yeah.
she admitted to fixing him, and that she was lying, and there was another guy who was actually her abuser?
Yes, Your Honor. So there was an email that the state argued that Mr. Potts had emailed to himself, pretending to be Miss Francis. And if the jury had believed that Miss Francis was the author of that letter, it essentially admits in a much more prejudicial way than simply somebody saying that she has a reputation for being a liar, that she fabricated all of the allegations, told her daughter to lie. And in addition to that, the Nairs were allowed to testify. Two of them testified about multiple things that that challenged some of her credibility, in the sense that they described her as essentially a meth addict and a raging alcoholic. Her cross-examination was fairly extensive, and she did have difficulty remembering exactly what happened on different dates. And so the state would suggest that even if the court decides that there was some form of error, that those pieces of evidence that Mr. Potts was allowed to present are far more impactful than a one-liner about somebody having a reputation for lying.
Was she cross-examined of specific instances of conduct of dishonesty?
About dishonesty, Your Honor?
Under 608B, I think it is, you can introduce specific instances of conduct when cross-examining a witness. You can't bring in extrinsic evidence, but you can ask them about specific instances of dishonesty. Did that happen?
No, Your Honor. What happened was he went through each of the instances that she had some memory of physical abuse and cross-examined her on her inability to remember kind of exactly what happened on those dates, because she had testified in a 404B motion prior to trial. So he was able to use some of that testimony to challenge what she said then in trial, which was sometimes inconsistent. So, and then I will move on to the second.
Ms. Lundgren?
Yes, Your Honor.
Let's assume, based on defense counsel's proffer of proof or proffer of evidence, that the trial court ruled that the testimony was admissible. Would the trial court have abused its discretion by admitting the evidence?
Yes, Your Honor.
And why so?
Mr. Potts had not presented sufficient evidence for the trial court to make a finding that this was a community and not a hand-selected group of friends, or that the community itself was neutral. He didn't establish the basic foundational elements of the number of people in the community, even the names or how they knew, the extent to which they knew Miss Francis. We simply don't have sufficient evidence for the trial court to have found that they were general and neutral. So moving on to the sufficiency of the evidence argument, I will just start by saying I believe that the state may have misapprehended Mr. Potts's argument to some extent, and for that reason did not address some of the parental discipline aspects of their argument. The state instructed on alternative A, the means of restraint by physical force, intimidation, or deception, and not on B, which involves the parental portion of that statute. There was no objection from defense. And so on a typical sufficiency challenge, the state is held to the burden of establishing the alternative means that it has asserted. And in the absence of the defense raising some type of argument on the basis of that statute, it is 9A 16-100. The defense was just arguing discipline in the sense that Mr. Potts had a different explanation of the story. It wasn't that he was challenging specifically the rights of a parent to discipline their child. It's that he had a different story altogether in which he was moderating between a dispute between the mother and the daughter. He did not raise that 9A 16100 as a defense. There is a WIPIC on it. He did not ask for that WIPIC to be used. That statute possibly only applies to the physical use of force on children. And so I'm not entirely sure that that statute does apply in this situation. But ultimately, the state's argument is not that a parent who commits DV in one instance in the past can never discipline their child. The issue is that this 10-year-old child had witnessed her mother being abused over a significant period of time. She heard her mother screaming. Mr. Potts was in a rage, and she was yelled at to come down, blamed for everything, and told that, and I see my time has run out. May I have time to briefly conclude?
You have 10 seconds.
Thank you, Your Honor. So this is more than sufficient, Your Honor, for the state to for the jury to have found beyond reasonable doubt that AF was falsely imprisoned. So for those reasons, the state would ask that the court affirm. Thank you.
Ms. Burkhart, did Mr. Potts tell AF to stay downstairs because of anger at being awakened?
Your Honor, that was one version of events that was offered. Notably, that was not AF's version of events. Her testimony was simply that there had been an argument between her and her mother. It went downstairs. She then left, went back upstairs. She heard the argument continue with shouting. Then Mr. Potts yelled at her to come downstairs, and she went. At that point, she saw her mother in the corner, and Mr. Potts told her she needed to stay in the room. So there's
Let's
nothing.
Assume that there's evidence that supports he told her to stay downstairs out of anger at being awakened. Would that be sufficient evidence for the conviction?
No, Your Honor, it's not a crime to be angry at your child.
Is it a crime to be angry at your child and direct that child to stay put when you're not motivated by discipline, but out of anger?
Well, Your Honor, I think that would be splitting hairs. I think it's fair to say that most parents who are grounding their children are probably angry with their children at that point in time. So I don't think it's a question of mixed motive. The question is simply the authority to act in the manner that he did. I suppose the argument could have been raised that would reflect on the reasonableness of his discipline actions, but reasonableness does tend to refer more to the actual means of discipline that are employed. So no, it's my position that even if he was angry, that would not change the legal analysis here. Thank you, Your Honor.
I want to read part of page 648 of the trial transcript. And this is the questioning of an officer. Question: was that topic discussed during your interview with him being Mr. Potts, at his house back in June? Answer: yes. Question: what did he say? Answer: he stated, quotes, "I know it is not lawful to keep someone from leaving if they want to leave. Probably shouldn't have done that." End of quotes. Is that testimony sufficient for the conviction?
It's not, Your Honor. And I think if you look at the context, part of the problem here is it's not clear whether he is referring to his wife or whether he is referring to the child. Different legal standards would apply depending on which one we're talking about.
Any other questions for Ms. Burkhart from the panel? Ms. Burkhart, I'll give you an extra 10 seconds also to summarize if you wish.
Well, thank you, Your Honor. For the reasons that I've stated, it's our position that given the context of the offer of proof, it was sufficient for the reputation evidence to be admitted, or at the very least, the trial court should have permitted an offer of proof from the proffered witnesses who there's no indication they were even present in the courthouse at the time that this colloquy took place. That there's no showing that any witnesses besides the Neers were individually biased in a way that would preclude them from accurately representing the reputation in the community. And finally, that credibility was the central issue in this case. And so this is more than simply a one-line, one-off. It's the question of who is generally more believable under these circumstances. And so the fact that Mr. Potts is not alone in his perspective that Ms. Francis was potentially a liar could have been of critical importance. Thank you.
Thank you, counsel. State versus Potts is submitted.
Because Potts failed to establish a recognized community in which neighbors were familiar with Megan Francis's reputation, the court rejected his evidentiary claim of error. Additionally, because the jury could reasonably find that Potts exceeded the bounds of lawful discipline in restraining his stepdaughter, the court rejected this challenge to the sufficiency of evidence. As such, his convictions were affirmed. Please let me know what you think about this case in the comments below. And if you like this video, please hit subscribe for more videos every week.